Hello and welcome to training today on diversity and inclusion and harassment in the workplace. I'll start with a little bit of background about who I am. My name is Trey Eubanks, and I have about 24 years of experience as a local government administrator in South Carolina. The past 3 years I've served as the Government Services Manager for the Appalachian Council of Governments. In that role, I provide support and technical assistance to elected officials and staff, and I do a lot of training. So that's why I'm here today to serve Oconee County and discuss these important topics. This is not going to be overly formal. There'll be some opportunities for Q&A and to get your questions answered, but we do want to cover the topics at hand, so we'll jump right in and start with diversity and inclusion. I want to go over the reasons why organizations work to enhance diversity. I want to give a definition of diversity and inclusion, and I want to discuss the differences between diversity and inclusion. And then I want to make a distinction between equal employment opportunity, affirmative action, and diversity and inclusion, and wrap it up with discussing the benefits of enhancing diversity and inclusion in the organization. And that's what Oconee County wants to achieve with this training. Why do organizations want to enhance diversity? What's the benefits to that? Why is Oconee County going through this process? Well, if you enhance diversity in the workplace, it deepens an employee's and other stakeholders' knowledge of the backgrounds, beliefs, and values of their employees and the stakeholders. It's equipped with this knowledge, the county can then modify policies, practices, and programs to improve how goods and services are delivered. Oconee County wants to satisfy the goals and priorities outlined in mission statements and strategic plans, to satisfy applicable employment laws, to increase employee engagement within the organization, to respond to a diversifying population of customers, residents, and other stakeholders, and to create an organization that will capitalize on the diverse collection of employees' backgrounds, knowledge, and experiences to develop greater problem-solving capacity. Innovation driver is what diversity can lead to. It really is an innovation driver. Other reasons to enhance diversity: legal compliance. Training on diversity promotes a work environment free from discrimination, and organizational effectiveness. Tangible benefits to enhancing diversity include more creativity, increased problem-solving and decision-making capabilities, and bringing into the decision-making process alternative points of view. What is diversity? Diversity is the mosaic of people who bring a variety of backgrounds, styles, perspectives, values, and beliefs as assets to the groups and organizations with which they interact. Another way to put diversity is the differences in racial and ethnical, socioeconomic, geographic, academic, and professional backgrounds. Diversity is the mix of people with different opinions, backgrounds, social experiences, religious beliefs, sexual orientation, heritage, life's experiences. There are primary and secondary drivers of diversity. Some of your primary drivers of diversity include your age, your gender, if you have a disability or not, your race, your sexual orientation, your age. Secondary dimensions of diversity include your geographic location, your education, your military experience if you've had any, your work experience, your communication style, your family status, your socioeconomic status. These are the different dimensions of diversity that create who you are. Let's define inclusion. Inclusion involves bringing together and harnessing diverse forces and resources in a way that is beneficial. Inclusion puts the concept and practice of diversity into action by creating an environment of involvement, respect, and connection, where the richness of ideas, backgrounds, and perspectives are harnessed to create greater business value and overall success. Another way to define inclusion is a culture where team members feel welcome and have the opportunity to contribute to the success of the organization. When we feel safe, when we feel a sense of belonging, not because we are the same as everyone else, but because we have been accepted as we are, is what inclusion means. The difference between diversity and inclusion: diversity is simply a representation of many different types of people, different genders, race, ability, religion, life experiences. Diversity is often focuses on the differences and is referred to as the mix. Think of the mix of the work team that you're on, your division or your department, or think of the mix that makes up Oconee County as a whole. Okay? Inclusion is a deliberate act of welcoming diversity and creating an environment where all different kinds of people can thrive and succeed. Inclusion is the act of making the mix work. And I want to emphasize this, especially for the supervisors, the leaders in this organization. You can be much more effective as a leader and get much more out of your work unit, out of your team, out of your division, out of your department, if you become familiar and work to create a culture within your work team, within your division, within your department that is inclusive. It gets more out of everybody. It rises the ability of the entire team to do more, higher morale, higher productivity. Diversity is what you have. Inclusion is what you do. Simply having a diverse group, team, or workforce isn't enough. Everyone should feel safe and encouraged to fully participate and share and be on equal footing with everyone else. That's the type of culture that you want to create, and if you work towards that, you will have a better work unit, a more productive team with higher morale. And if we've got to do something 40 hours a week, let's create a good work environment, right? Okay, the distinction between equal employment opportunity, affirmative action, and diversity and inclusion. Equal employment opportunity is the enforcement of statutes to prevent employment discrimination. Affirmative action is the effort to achieve parity in the workforce through outreach and eliminating barriers in hiring. And diversity and inclusion is leveraging the differences in the workforce to achieve better results. I just want to emphasize again, particularly for the supervisors and the leaders out there within Oconee County and this team, you can get better results if you work to leverage the differences with your work unit, with your team. Let's talk about the benefits of enhancing diversity and inclusion in the workforce. An improved understanding of who you work for, with, and around. It creates a work environment that allows everyone to reach their full potential. It provides multiple perspectives on problem solving. It results in better performance outcomes. It increases productivity. It increases retention rates. It boosts morale. It improves customer relations. And it reduces complaints and grievances. Bottom line, it's just the right thing to do, okay? The research shows that workforce diversity is positively associated with higher business performance outcome measures. Racial diversity is positively associated with higher performance in organizations that integrate and leverage diverse perspectives as resources for product delivery. And gender diversity is positively associated with more effective group processes and performance in organizations with people-oriented performance cultures. Diversity enhances performance, but it requires attention. Other benefits to diversity: it prepares employees for future career success. Successful performance in today's diverse workforce requires sensitivity to human differences and the ability to relate to people from different cultural backgrounds. And I want to emphasize that our workforce is becoming increasingly diverse. There are 5 generations in the workforce now. There are more people moving into the workplace with a different ethnic background, from a different country possibly, different religious beliefs. That diversity is increasing, and we have to be able to work with that. And for the managers and the supervisors, sometimes that's going to require you to be a little bit more flexible in your management style. The traditionalists have different work characteristics than Generation X and Generation Y, right? But the young folks, they bring a lot to the table. They're very innovative. They're multitaskers. They're technologically savvy. So if you can be flexible to get the most out of everybody within your work unit, you're going to be better. You're going to see a lot more productivity out of your work unit. Diversity promotes creative thinking. Diversity expands our capacity for viewing issues or problems from multiple perspectives, angles, and vantage points. Diversity enhances self-awareness. Learning from people whose backgrounds and experiences differ from our own sharpens our self-knowledge and self-insight by allowing us to compare and contrast our life experiences with others whose life experiences differ sharply from our own. Interactions with people different from ourselves increase our knowledge base. Research consistently shows that we learn more from people who are different from us than we do from people who are similar to us. We've all heard of the golden rule. You probably learned that in kindergarten or Sunday school, right? Treat each other as you would like to be treated. I want to speak to the platinum rule. This says that you should treat others the way they want to be treated. It's a step at empathy, okay? Put yourself in that person's perspective. And this is increasingly important as the diversity on your team increases. The way that you communicate, you've got to make sure you're being effective. And people from different backgrounds receive messages differently. So be mindful of this. Put yourself in their position and make sure that you're behaving, communicating with them so that the message that you're sending them is well received and accurate and most effective. You'll be better off if you can do that. Some takeaways on diversity and inclusion. It absolutely does enhance performance and productivity in the workforce. To be effective, diversity management must be strategically implemented and aligned with the organizational goals. This is important to Oconee County. That's why we're training on this topic. Diversity requires investment and attention in order to be effective. Intolerance and insensitivity to diversity breeds low morale and costly results. Organizations must empower employees and guarantee their rights. Diversity principles must be incorporated in all aspects of an organization's culture, including leadership communications, recruitment and retention strategies, rewards and developmental systems, group work processes, succession planning, and strategic planning. All right, that concludes the topic of diversity and inclusion. Again, be mindful of it. I hope that you pick something up that you can learn from and appreciate and apply that's going to benefit you as you go forward and advance your careers and serve Oconee County. The next topic we're going to discuss is harassment. For the next little bit of time, I want us to define and recognize harassment and offensive behaviors, understand the federal and state laws regarding harassment in the workforce, work on preventing harassment. What are some best practices for that? Handling harassment claims and investigation, understanding the cost and penalties associated with sexual harassment, and we're going to wrap it up and conclude with a review of some court cases pertaining to harassment claims to reinforce what we're getting ready to go over and talk about. What is harassment? Workplace harassment is unwelcome behavior directed at a person based on race, color, sex, national origin, age, or disability. Harassment becomes unlawful when enduring the offensive conduct becomes a condition of employment, or the conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Now, I want to point out that petty slights, annoyances, isolated incidents, unless they're pretty extreme, are not going to necessarily rise to the level of illegality. Again, to be unlawful, the conduct must create a workplace environment that is intimidating, hostile, or offensive to a reasonable person. Offensive conduct may include, but is not limited to, offensive jokes, slurs, epithets, name-calling, physical assaults, threats, intimidation, ridicule, mockery, insults, put down, offensive objects or pictures, anything that can interfere with someone else's work performance. Employees are encouraged to inform the harasser directly that the conduct is unwelcome and it needs to stop. Employees should also report harassment to their higher up at an early stage to prevent it from escalating. Types of harassing behavior, and this is pretty common sense. This is innate to a lot of us, but sexual chatter, inappropriate pinups or cartoons, excessive flirting, slurs or innuendos, gestures, threats, passes. These are examples of harassing behavior, things that can be harassing. Some examples of physical behavior that can constitute sexual harassment could be unwanted or inappropriate physical contact, such as patting, pinching, stroking, or brushing up against someone. Attempted or actual kissing or fondling. Standing too close. Everybody has their personal space. If you get too close to someone, that could be offensive to them. Excessively lengthy handshakes. Physical assaults, and all the way to the extreme of coerced sexual intercourse. Well-intended gestures, such as a pat on the shoulder, touching, lewd comments, jesting comments, physical contact. These may be interpreted as sexual harassment by one recipient, while somebody else might dismiss it as just joking around or annoying. Some individuals may perceive leering or staring as sexual harassment. Others might perceive that same behavior as just looking. Accused harassers may not have intended to commit an act of harassment, and they may believe that their conduct is appropriate, acceptable, and even appreciated. Important thing to remember is any type of unwanted physical or verbal conduct can be offensive to an individual, and every one of us have a responsibility to be aware of how our behavior is affecting another person, okay? Do not, and this is again common sense, but don't tell sexual or discriminatory jokes, make innuendos, leer, stare, hug, touch, pressure for favors, give sexually suggestive or sensitive visuals. These are examples of things that you don't need to do that can be offensive to somebody else and could constitute sexual harassment. There are some tests that you can apply to yourself to see whether or not behavior is harassing. Ask yourself, would you want your behavior to be featured on the evening news? Ask yourself if you want would you behave the same way if your family was present to observe what you're doing, how you're acting? Would you want someone to act a certain way to your wife, to your child? Is there equal initiation and participation between the person that you're interacting? All right, employer liability. An employer can be held liable for harassment by a supervisor when that supervisor causes negative employment action, such as termination, failure to promote, loss of wages, a reassignment in duties, a reduction in benefits, anything like that. If a supervisor's harassing behavior results in a hostile work environment, the employer can avoid liability if it can prove that it reasonably tried to prevent and acted promptly to correct the harassing behavior, and the employee unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer. The employer may be held liable for harassment by non-supervisory employees, such as an independent contractor, if the employer knew or should have known about the harassment and failed to take prompt and appropriate corrective action. So the key here to provide a liability shield to Oconee County is that if there is this type of behavior does take place, address it, act appropriately to do that. And the way to do that, go to your higher ups, make your department head aware of it, make human resources aware of the issues, and get guidance on how to handle them. That is going to protect Oconee County from lawsuits. Okay, the Title VII of the Civil Rights Act of 1964 is the federal law that prohibits discrimination against employees based off race, color, religion, sex, national origin, age, disability, sexual orientation, and it also makes it unlawful to discriminate against someone that has made a charge or testified, assisted, or participated in any manner in an investigation, proceeding, or hearing pertaining to an allegation of sexual harassment. So you can't retaliate if somebody makes a claim or participates in an investigation of sexual harassment claims. There are a couple of different types of sexual harassment. There is quid pro quo, or this for that sexual harassment. This refers to situations where employment decisions, such as hiring, firing, or promotions, are contingent upon the employee providing sexual favors. Examples of quid pro quo sexual harassment are when a supervisor threatens to fire an employee who does not submit to sexual advances, or where a supervisor promises to promote an employee in exchange for sexual favors. There's also hostile work environment. Hostile work environment sexual harassment refers to situations where the employee's work environment is made intimidating, hostile, or offensive due to unwelcome sexual conduct, and that conduct interferes with the employee's work performance. Examples of hostile work sexual harassment include making offensive sexual comments, jokes, discussions about sex, any display of sexual-oriented materials. Electronic communication. Sexual harassment includes sending harassing messages via email, text, or social media, social network sites. Emails and text messages sent from personal accounts to coworkers' personal or work accounts could constitute sexual harassment. Posts on networking sites that can be viewed by persons outside the employee's network of friends that are harassing in nature need to be reported. Employees should report harassment sent by text or social media. Bottom line is, acceptable workplace behavior and etiquette standards need to be observed in electronic communications. And I do also want to add, technology is great. If you have a cell phone or a laptop or an iPad provided to you by Oconee County, the information on that device is discoverable under the Freedom of Information Act. So be aware of that. All right, let's talk about the EEOC and harassment claims. The EEOC is a federal agency that's going to investigate claims of harassment if they get to that point. If they can't be resolved by the business or the local government, and it goes further, it's going to go to the EEOC. They're going to look, when they're investigating a claim, they're going to look at the frequency of the harassment. They're going to look to see if the conduct was hostile or patently offensive. They're going to look to see if the harasser was a coworker or a supervisor. They're going to want to know if others joined in the harassment, and their investigation is going to include whether or not the harassment was directed at more than one individual. The EEOC then is going to make their assessment based off the totality of the harassment circumstance. I want to point out some of the data from EEOC. If you can see the chart from 2012 to 2017, the number of claims of sexual harassment, allegations of sexual harassment decreased each year. But from 2017 to 2018, they jumped way back up. Why was that? Well, if you can recall, Harvey Weinstein, the Me Too movement, this brought a lot of attention to the topic of sexual harassment, and the EEOC's allegations that they investigated increased significantly. Just some other stats there, but the trends are basically, the points that I want to convey are that sexual harassment charges with the EEOC increased by more than 12% from 2017 to 2018, which is the first time in more than a decade that the number of complaints had increased. Sexual harassment lawsuits filed by the EEOC's attorneys increased by 50% from 2017 to 2018. 1 year, they doubled. Monetary awards for the victims of sexual harassment rose to $68.2 million in 2019, which is an increase of 21% from 2018 and 47% from 2017. The public's interest in EEOC sexual harassment efforts, enforcement efforts, have also increased. The EEOC reported that visits to its sexual harassment website page more than doubled from 2017 to 2018. The monetary awards, again, that 47% increase to $68.2 million from 2017 to 2019, that's real. That's a big number. It can become costly. That's why it's prudent for local governments to promote a workplace culture that deters sexual harassment and discrimination. EEOC says that prevention is the best tool for eliminating harassment, and that it encourages every employer to take all steps necessary to prevent it. What can we do to prevent sexual harassment and discrimination? Provide training on the subject. That's what this is about right now, the reason that we're here. Express strong disapproval. And I really want to encourage particularly you leaders within Oconee County, you supervisors that have people working for you. If you see somebody that gets out of line, this behavior is crossing the line to becoming inappropriate, step in and call them out about it. Again, we're working 40 hours a week with each other as a team. We want a culture, we want a workplace that is high morale. It's a fun place to work. You want to come in and get it done. You want to enjoy the people that you're working with. You want to have a good culture within the organization. Sexual harassment has no place in an organization. It can draw down morale. It can create all kinds of problems. So if you're a leader out there, and anybody has a right to do this, but particularly I want you leaders, you supervisors to step up and express strong disapproval if you see it taking place. Develop appropriate sanctions. Inform employees of their rights and their ability to raise the issue of harassment. And these are spelled out in your personnel policy, okay? And develop methods to sensitize all concerned in order to reduce and eliminate harassment in the workplace. There are penalties associated with sexual harassment claims and cases. There could be payment of lost wages to the victim. These are the benefits and wages that the victim would have earned from the date when the harassment occurred to the date of the settlement. There are payment of future lost wages to the victim. These are payments to the victim of the wages and benefits that the victim would have earned if the sexual harassment had never happened. There are compensatory damages, which are payments that the employer may be ordered to pay to the victim for emotional pain and anguish that the victim has suffered. There could be punitive damages. These are payments that are above and beyond the economic and non-economic losses that were suffered by the victim, and these are designed to punish the employer. And I just want to emphasize that's why it is so important to handle these claims and allegations of sexual harassment properly. Address them. Don't sweep them under the rug or hope they'll go away. Step up, step in, and make sure they're addressed and addressed properly. If If you know what's going on, talk to your supervisor, talk to human resources, and make sure it's being handled properly. You don't want to put Oconee County in a position to where you're going to have compensatory damages or punitive damages associated with a sexual harassment claim. The legal fees are payments to the victim for the court fees and attorney's costs that the victim incurred as a result of the sexual harassment case. And there could also be job reinstatement or promotion, which is an order to reinstate the victim to his or her job or to give the victim a promotion. There are also penalties against a sexual harasser. If it's a minor infraction, it could be a reprimand or a warning. You might need to step it up and require some mandatory training and counseling. It might be a case where a transfer or a demotion is warranted. Could call for reduction in salary or suspension. And if it's a pretty serious and severe case, termination is certainly a possibility. As I said, it's important to report all claims of sexual harassment, but sometimes employees refrain from reporting harassment, and there are reasons for that. They might be concerned about being believed. They might be embarrassed. They might fear for their safety, or fear that nothing's going to be done, or fear that they may be discharged or blamed for the harassment. They might be afraid that the complaint's not going to be taken seriously, or they might just believe that if they ignore the behavior, the harassment's going to stop. There's also excuses that some make for not investigating harassment claims. And these might include somebody, a supervisor, or somebody thinking if their claim is brought to their attention, they might just say, oh, you're overreacting, you're being oversensitive, you just misunderstood, he's just that way, he does it to everyone, he's harmless. Or you might just be in denial about bad behavior happening. But it is important to handle every one of these allegations and claims and handle them properly, okay? Here's a checklist for supervisors. Ensure you are familiar with your organization's harassment policy and procedures. Know the administrative resources available to process a complaint of harassment. And this is spelled out in your personnel policy, okay? Provide the complainant and the accused employee the opportunity to discuss the incident informally and in confidence. And again, you need to take it to your higher up. You might not necessarily be directly involved in this, but make sure your supervisor, your department head, human resources is aware of this. They're going to know exactly what steps to take to handle these cases. But you as a supervisor know that once you receive complaints or inquiries about sexual harassment, you need to notify the appropriate channels immediately so that an investigation can take place. And again, an immediate investigation of the alleged conduct needs to be conducted by a neutral, objective person in accordance with the organization's policy. Your supervisor, your department head, human resources is going to give you the guidance and direction that you need if you have to get involved or if you become aware of a sexual harassment complaint. But it is critical that you investigate all of them. Even if somebody says, listen, I don't want to make a big deal out of this, but here's what's going on. Investigate that. Create a matter of record so that you can protect Oconee from a liability standpoint, okay? Another reason that you want to investigate all these claims, if you take it seriously, it serves as a deterrent for this inappropriate behavior. And again, you want to promote a good workplace environment. You want to have a good place to work, a good culture to work in and be a part of, right? And then finally, it's important to investigate because of your organizational image. If you think back over the past year, 2 years, maybe not even that long, you can come up with an incident that an employee, a supervisor, an elected official has done some things that are inappropriate, and that's going to be front page story, right? That's going to be the headline on the news. And that is really putting a stain on the image of that organization. So if you handle these things correctly, first of all, you're going to deter it, but you're also going to protect it from a liability standpoint. And if you handle it correctly, it's going to help from an image standpoint as well. some guidelines for conducting an investigation. Make sure the investigation is thorough and prompt. If there's more than one allegation, treat each incident separately. A claim may appear to be frivolous on the surface, but treat it as valid until you have established otherwise. In other words, create a record of every one of these claims. Develop a complete and accurate investigation summary. Keep the investigation and the facts discovered under a strict need-to-know basis. You want to honor the confidentiality in these cases. Limit the number of persons in the organization who have access to the information. Consider having the investigation conducted by HR, legal, or an outside investigator, especially the high-profile claims. And never broadcast the facts of a sexual harassment claim. Now, you need to resolve these complaints. Once you complete your investigation and you have the facts, take prompt corrective action if harassment is found. When attempting to remedy harassment, avoid requiring the claimant to work less desirable hours or in a less desirable location. You want to make certain that you don't want somebody that alleges or has a claim of sexual harassment that they feel they're being punished. So you want to make sure you don't put them in a less desirable location or give them less desirable work hours. Ensure that any response is well-founded based off the facts of the investigative record and in accordance with the organizational policy. And when you're doling out the discipline, consider the severity, frequency, and pervasiveness of the conduct. Again, basically make sure the punishment fits the crime. Make sure that you have good judgment on this. This is where your supervisor, your department head, or human resources really needs to kind of help weigh in and decide what actions to take if the investigation reveals that there was harassment. But once you dole out the discipline, you're not done. You need to make sure to follow up. If it's somebody that, if you're a supervisor and it's one of your employees has had this happen to and deal with, make sure you monitor and follow up to ensure that the remedy's been effective and the harassment is ended. A failure to follow up can result in liability exposure if the harassment continues. If the remedy's been ineffective, enhance the response and make follow-up inquiries to ensure that the victim and witnesses have not suffered any retaliation. I want to review a handful of court rulings to emphasize some of the points we've discussed. The first one I want to review is Burlington Industries versus Ellerth. Kimberly Ellerth was a female employee at Burlington Industries. She sued for sexual harassment, alleging the vice president of sales made offensive remarks and unwanted overtures and stated he could make her life or her job very easy or very hard. She identified 3 episodes involving threats to deny tangible job benefits unless sexual favors were granted. She rebuffed his advances, and she never suffered any tangible job detriment. In fact, she got a promotion prior to quitting. She never informed management of her supervisor's conduct. This went to trial, and the lower court dismissed her claim, noting that she had suffered no actual negative job consequences. This was appealed to the Seventh Circuit Court of Appeals, and they reversed the lower court's decision and said Ellerth could go to trial. This went all the way to the Supreme Court, and the Supreme Court upheld the Seventh Circuit Court's ruling. In this case, and this is the landmark of this case, the Supreme Court ruled that an employer can be held liable for sexual harassment and can be sued regardless of whether or not a supervisor's threats were carried out. From a legal standpoint, this next part is really the meat of this case. They also ruled that employers may be relieved of liability if the employer can prove that they exercised reasonable care to prevent and they acted quickly to correct any sexual harassment behavior. And the employee unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer. Generally speaking, having an effective sexual harassment policy, which Oconee County does, that is used and implemented is sufficient to satisfy the first condition. Okay, the next case, Farragher versus the City of Boca Raton. Beth Farragher was a lifeguard for the City of Boca Raton. She claims she endured repeated sexual harassment from 2 male supervisors during the 5 years she worked for the city. Farragher and 7 other female lifeguards, Farragher and 7 other female lifeguards claimed the 2 supervisors grabbed them by their breasts and buttocks, tried to break into their showers, and referred to them regularly by vulgar epithets. Farragher stated she did not report the problem to management because she feared retaliation. The city argued that they should not be held liable because it had a clear policy against sexual harassment and because the supervisors were acting on their own and not as representatives of the city. The city did not disseminate their policy to the employees. A lower court ruled that while the girls had in fact been harassed, the city couldn't be held liable for the harassment because the city didn't know it was happening. This case made it to the Supreme Court, and the Supreme Court ruled that an employer is liable for a pervasive, hostile atmosphere of harassment, and that the city could be held liable because its officials made no attempt to monitor supervisors' behavior, and the city failed to circulate a policy against sexual harassment to its employees. Okay, Crawford versus the Metropolitan Government of Nashville. Vicki Crawford made claims of sexual harassment during her employment with the school district for Metropolitan Government of Nashville in Davidson County in Tennessee. She served as a payroll coordinator for the school system for more than 30 years. In 2001, the school district hired Dr. Jean Hughes as its employee relations director, a position whose responsibilities included investigating complaints of discrimination. Early in the course of his employment, several administrative employees complained of inappropriate behavior by Hughes, and because of the obvious conflict of interest, the complaints were investigated by another administrator in the school's HR division. The investigator asked to interview several employees, including petitioner Vicki Crawford, about their interactions with Hughes. During the interview, Crawford disclosed that Hughes had sexually harassed her and other employees. 3 other employees made similar allegations. After making these allegations, all 4 employees were terminated. Crawford was terminated based on charges of embezzlement and drug use that were ultimately determined to be unfounded. After her termination, Crawford filed a discrimination complaint with the EEOC and subsequently received a right to sue notice. Crawford then filed suit under the non-retaliation provision of Title VII, which protects an employee who participates in an investigation in connection with a pending EEOC charge. The Supreme Court ruled that an employee may be protected from retaliation under the opposition clause if he or she discloses information as part of an internal investigation. This ended up being a pretty costly case for the school district. The jury returned a verdict in Crawford's favor for over $1.5 million. So again, don't retaliate. You cannot retaliate for if anyone is participating or filing a claim against of sexual harassment at the EEOC. The final case I want to touch on, it basically defines from a legal standpoint who is a supervisor. This is the Vance versus Ball State University case, and this states that in the eyes of the law, a person is a supervisor if they can make a tangible employment action. Tangible employment action includes hiring, firing, promotion, a reassignment with significantly different responsibilities, or a decision causing a significant change in benefits. If an employee has the ability to make a tangible employment action, they are a supervisor, and the employer can be held liable for their actions, okay? Now, just a summary to wrap up. Make sure that the policy has definition and examples of sexual harassment, direction on reporting harassment, and protection against retaliation. And it does. It's a good policy. Make sure, particularly if you're a supervisor, that you're aware of it. Ensure all of your new employees receive the policy, and conduct regular training for all of your employees. That's what we're doing in this session right now, correct? All right? Remember, when investigating sexual harassment claims, document, document, document. You've got to create a record of that investigation. Ensure that any investigation is conducted properly and comprehensively. And again, you certainly have the ability to take this up to the next level involving your supervisor, your department head, or HR, okay? And if it's a high-profile claim, if it involves, say, a department head or an elected official, it might be a good idea to consider outsourcing that investigation to a legal counsel or to an outside investigator. The key point here is just to do what you can to eradicate sexual harassment from the work culture here. If it would offend your mother, your father, your spouse, your child, it doesn't belong in the workplace. All employees have the right to work in an environment free from all forms of discrimination and conduct that is harassing, coercive, and disruptive. People are in an environment where they're together and interacting many hours a day. Relationships develop. It's stressed that the relationships be of the appropriate type. Again, do your part to create an organizational culture that deters harassment. It'll be a better work environment. If you got to be here 40 hours plus a week to do it, make it a good place to be, right? Work to eliminate this type behavior if you see it happening. All right. Thank you very much for your attention. Thank you for all that you do for Oconee County. I wish you the best in your career.